Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is what? It's not only merger control, the rise of foreign direct investment controls worldwide. As the practice of mergers and acquisitions has become global, competition law clearance has often become an important, if not the last, gating item. But in addition to competition law, other regimes and factors often play a role in merger clearance. In some jurisdictions, for example, national security or even labor concerns must be addressed before a deal is cleared by the regulatory authorities. So today we're going to talk to two experts who deal with these foreign direct investment regimes worldwide and learn a little bit more about how that plays into merger clearance. My co-host today is Matthew Hall. Hi, Matthew.
Hello, John. It's good to be back.
Matthew, what are we doing today?
As you said, John, we're looking at the increasingly important area of foreign direct investment controls or clearances, which are often needed for transactions alongside your normal merger control. The FDI rules usually focus on particular sensitive sectors and or on foreign acquirers. And it's becoming, as you said, a very important and increasingly important and difficult part of worldwide merger work. And it's very, very hot and important. And I think it's likely to stay so in the current circumstances.
Great. Who are our guests today?
Well, John, we have Calvin Goldman of the law firm Goodmans in Toronto, Canada. Cal is co-chair of the Competition, Antitrust and Foreign Investment Group at Goodmans. His practice covers all aspects of Canadian competition and merger law, as well as foreign investment matters under the Investment Canada Act. And he is a former head of the Canadian Competition Bureau. Amongst many other positions, he's also co-chaired not one but two ABA antitrust law section task forces in recent years, which have looked at foreign investment issues. Hello, Cal.
Hello, Matthew. Hello, John. Very pleased to be here. Thank you.
Great. And we also have Lisa Wright from the law firm Slaughter and May. Lisa advises in relation to all aspects of EU and UK competition and regulatory work, including merger control, antitrust, and state aid. She also advises on what we're looking at today, foreign investment issues. She works in both the firm's London and Brussels offices. Hello, Lisa.
Hi, Matthew.
So, Cal and Lisa, again, thank you for joining us today. As I mentioned, a lot is going on in this area. There are a lot of hot topics. But Lisa, if I can just ask you to briefly refer to a couple of the really key recent developments at the EU. In the EU, I think there's been a fairly recent a white paper, and also as a result of the pandemic, there's been some recent guidance, what I think seem to be emergency guidance from the European Commission on FDI. So are those are some hot topics which I think is useful to look at?
Yeah, absolutely. I think at the EU level, in terms of FDI and related topics, there's probably three key things to highlight. The first would be the EU's FDI regulation, which was adopted last year, but is due to come into force in October of this year. And that regulation introduces a mechanism for cooperation and information sharing between the European Commission and the member states in respect of FDI screening processes taking place at member state level. The second thing I would highlight is what you just mentioned. So when the COVID-19 crisis was really escalating in Europe back in March, we saw the European Commission published guidance urging member states in pretty strong terms to use FDI screening to protect companies that might be important to Europe's response to the pandemic from foreign investment. And in the wake of that guidance, we've seen a number of member states taking steps to expand their FDI controls or to introduce FDI screening where they didn't already have it. The third development I think I would highlight, which is separate from FDI screening, but I think intrinsically related to it, is the European Commission's proposal for new powers to deal with distortions caused by foreign subsidies in the EU single market, which was published recently. And they include a proposal for a new general review power to investigate foreign subsidies, which are thought to be distorting competition in Europe. A notification and approval regime for companies benefiting from foreign subsidies who want to make acquisitions in Europe. And lastly, a regime to control participation of companies benefiting from foreign subsidies in European public contracts. So there is quite a lot happening on the EU front.
As you say, a lot happening. And the white paper has been a long time in coming, I think it's fair to say, and is a pretty amazing document if you consider where we've come from. And a lot will be happening on that over the next few months. And of course, you've not talked about there, and we can talk about it later, everything that's been going on at the national level in the EU, not only in the UK, but elsewhere in recent months. Cal, what about you? What do you see as the real hot topics from your part of the world or elsewhere?
Thanks, Matthew. The expanding focus on the scope of national security reviews continues to be a hot topic, as you might say. I'll illustrate this in a couple of respects. First, there is a draft legislative proposal before Parliament that would give the minister responsible for reviews under the Investment Canada Act an additional 6 months to issue an order that launches the national security review process in Canada. That's a considerable extension, well and beyond the usual 90-day timeframe. That's an initial 45 plus a further 45 days to give such notices with the national security review to follow. It's a substantial addition of time in which the government would have authority to conduct a full national security review. In addition to that, we are seeing similar expansion of the scope of national security reviews, as our ABA task forces have noted in the last two reports that we've done. We're seeing the same thing in Canada, and I'll give you one example. Very recently, in March of this year, an initial notice of a possible national security review that essentially freezes the transaction under the Act until such is decided. That was issued to Endeavour Mining, which, albeit is incorporated in Canada, but has its main operations headquartered, as I understand it, in London. It is proposing to buy Semafo Inc., which is also incorporated in Canada with headquarters in Montreal. This is interesting because Semafo is engaged, as I understand it from public information, only in gold mining in West Africa. So a good number of us are wondering, what is the basis for a possible national security issue in relation to that? That speaks for itself.
That's interesting, a lot of head scratching. And I think that reflects, however, what we're seeing in practice, which is that every time you look at a transaction, you really need to think, is this going to be caught by FDI rules because of the increasing scope of sectoral and general coverage. And that 6 month issue sounds pretty concerning as well. But Cal, stepping back, I know that you've thought a lot about the bigger picture and what is driving the real expansion of the FDI rules, which we just referred to in the EU, but also in the US. A lot of it, I think, is kind of geopolitical US-China tensions, but maybe you could give us your thoughts on that, because I know you have thought about it quite a lot.
It's a good question, Matthew. The Canadian government, through the Minister responsible for the Investment Canada Act, Minister of ISED, as we call it, Industry, Science and Economic Development, recently issued a policy statement indicating that there would be enhanced scrutiny of any proposed investments in Canadian businesses that relate to public health or the supply of critical goods and services to Canadians. That, of course, arises from the COVID-19 pandemic. In addition, to answer your question, all investments by state-owned acquirers, that's SOEs as we call them, are going to be subject to enhanced scrutiny, regardless of the value, regardless of the usual threshold that is approximately 428 million Canadian. That is a reflection of increasing focus on state-owned enterprises. And in addition to that focus, I'll get to your geopolitical point and question in a second. There is a new study before our House of Parliament Standing Committee on Industry, Science and Technology that is looking at a number of possible changes to the Investment Canada Act, including whether Canada should place a temporary moratorium on acquisitions from state-owned enterprises of authoritarian countries. Now, the statistics released publicly by the Investment Review Division under the Investment Canada Act have indicated that approximately 80% of national security notices that have been issued in recent years pertain to acquisitions coming from China and Russia. That isn't said directly in the review of this temporary moratorium on acquisitions from such state-owned enterprises, but one only has to look at that and see where the direction would be most affected. That is coming from China and Russia. Now, Canada is a member of the Five Eyes, along with the United States, the UK, Australia, and New Zealand. Canada's national security reviews are generally done, as we understand it, with very close cooperation with counterpart national security authorities in the US and other members of the Five Eyes, in addition to working with counterparts in Europe. The recent geopolitical tensions that have developed, as we've all read, between the United States and China, along with some of the additional tensions that have arisen publicly coming from the detention of the senior Huawei executive in Vancouver, pending extradition proceedings from Canada to the US, all have given rise, all of this is a confluence that has given rise to anticipated greater scrutiny, greater focus, greater timelines, and potentially broader issues relating to investments coming from China and other parts of the globe where there may be national security issues or, and it's actually, and state-owned enterprise acquisitions that give rise to possible national security concerns going forward. So
very interesting, Cal. So, I mean, the Five Eyes is therefore maybe if expanding its reach beyond pure intelligence sharing. It also has an impact on transactions. I think let's pause there and move on and just head on a bit to the legal structure. Lisa, you were mentioning earlier, talking about really what's been going on at the EU level, but of course, the EU is a number of member states. A lot of the FDI work is carried out at the member state level, subject to EU treaty obligations. So could you just educate us on how that works? And also considering what is a foreign acquirer from the point of view of the EU or those national rules that are relevant in the EU.
Yeah. So, I mean, I guess the first point to mention is that there is no sort of overarching EU-wide FDI screening regime. There's nothing like we have in the field of merger control, where you've got the European Commission reviewing transactions which hit certain turnover thresholds on behalf of member states. We do not have that in FDI. And the FDI regulation that I mentioned earlier does not create that. That is purely, it's a significant development, I think, but it is purely a framework for cooperation and the sharing of information between member states and the European Commission. So, you're right, Matthew, all of the FDI screening that happens in Europe happens at member state level, according to whatever the relevant national rules provide for. And there, is as yet no harmonization across Europe in terms of, what sort of transactions are caught, what are critical industries for these purposes, and which types of acquirers are have to go and get FDI approval.
So unlike merger control, where, as you say, there's an EU-wide regime, and even where not, generally the competition law principles are pretty similar at the national level. It's different in FDI. Do you think that the FDI screening regulation will lead to greater convergence EU-wide on the rules, or is that just going to take some time?
Yeah, I can see that it may well go in that direction because, to the extent that you've got agencies in one country cooperating more closely with and sharing information with, agencies in other countries, I think probably naturally over time that might drive some convergence. And, then you have developments like we saw in March with the European Commission coming out with that guidance, urging all member states to, make sure that their FDI regimes were kind of fit for purpose in terms of defending European companies that were important to the pandemic response, defending those from, foreign takeover. And that then spawned, I think, a round of member states, amending regimes to make sure those sorts of industries were covered. So, I think you're right. At the time, we may well start to see some convergence.
And probably more countries having rules. I think I looked up recently, and even now, or even only about 15 or so member states within the EU, including the UK or plus the UK, have some kind of rules. So it's quite surprising, really. Obviously, the big countries do, but not all of them.
Yeah, no, absolutely. And I think the UK is quite an interesting example there because it doesn't currently have an FDI screening regime. The government has some powers to intervene in transactions which present national security and other concerns, but they're pretty limited powers, and they're in particular only triggered where the transactions meet the thresholds for either UK or EU merger control review. So it's not a standalone FDI regime, but the government is actually looking to change that and has said that it will be bringing forward legislation to introduce a standalone screening regime. So it is coming in the UK too.
Which could be quite wide-ranging. We might get onto that. But, Cal, I think, you've been talking about the Investment Canada Act. It's a bit simpler in Canada and elsewhere, isn't it? We don't have this EU/member state divide or strange division, or do you see it differently in practice?
No, I don't see it differently, and I'm happy to discuss the interface with Competition Bureau merger reviews under the Competition Act. But before I do that, Matthew, I want to just clarify that while I referred to the increasing focus on foreign investment reviews relating to national security issues, I, for one, do not believe the possible addition of a temporary moratorium on acquisitions from state-owned enterprises of authoritarian countries is in any way necessary at this time. And I think to put a framework around what is happening, unfortunately, we are seeing a rise of significant new protectionist measures in the Western world in relation to foreign investment. That's a reversal of the last 25, 30 years of great work that has been directed toward trade liberalization. Canada does need significant ongoing foreign investment to enable our economy to grow. We're not alone in this respect. And adding unnecessary fuel to the protectionist fires is the wrong direction in my view. We should be cooperating to the extent possible and encouraging trade liberalization, except where there is indeed a very real national security issue, and particularly at this time that may be affected by the impact of the pandemic. I wanted to make that clear.
Yeah, absolutely. That's clear. And I mean, as you say, this increased focus on FDI is paralleled in other areas, not least classic international trade relations.
Well,
and
Matthew,
law.
let me just give you an example, a further one. Canada has raised the threshold for our net benefit reviews in accordance with the statutory factors in Section 20 of the Investment Canada Act to $1.613 billion. That's very, very high when the acquirer on a direct investment comes from a country with a trade agreement with Canada. And that is a reflection of the progressive steps toward liberalization. Such trade agreements include Canada with the United States, Mexico, and member states of the European Union. There is a lesser threshold for WTO members, $1.075 billion, and then state-owned enterprises, as I said, Canadian $428 million in asset book value. There's a proposal as well before our industry committee of the House of Commons to look at lowering these thresholds, as was done recently by Australia, which dropped the review thresholds to zero. They went that far. So we're not alone in looking at this. Australia has already taken action. And again, all of it reflects an increasing sweep of foreign direct investment reviews in various parts of the globe.
Absolutely. And we're unfortunately limited in time on the podcast. There's so much to talk about. I wanted to definitely get on to some practical tips on how you guys as experts manage these processes on transactions around the world. But before doing that, I wanted to have a brief chat about the pandemic, COVID-19. I've seen some comments that issues thrown up by the pandemic are going to be taken into account in FDI, which haven't really been thought about before. Lisa, do you have any thoughts about that, or indeed other you mentioned the UK regime, which is coming in, and it's going to be quite wide-ranging in its scope in terms of what could be caught, or the target assets which could be caught. Do you have any thoughts in this area on things we should be looking for going forward in terms of expanded reach of these rules in the EU and or UK?
Yeah, so I mean, maybe if I just look at what's happening in the UK as a starting point. So, obviously kind of proposals and steps to introduce this new regime have been, kind of around and discussed for a couple of years now. And if you look back at the consultation documents from about 2018, when the government published a white paper, that gives you, I think, a good insight into the key concerns that the UK government at least had about FDI in a kind of pre-COVID world. So that white paper proposed a regime for the review of transactions on national security grounds only, and specifically covered the acquisition of IP or land, and also investment in core areas of the economy. So that included, I think, civil, nuclear, communications, defense, energy, and the transport sectors. And I think, all of these are still relevant, but obviously now we have COVID-19, and that I think has expanded the areas that governments and their agencies will look at in these screening processes now. So I think we will now see, and we are now seeing FDI screening focusing on businesses that are particularly vulnerable to opportunistic FDI, in light of the economic fallout from COVID, and in particular to businesses which are important in some sense to the to European countries' ability to respond to this pandemic or indeed to future ones. So, typically that would be companies involved in healthcare or biotech, but it may well be broader than that. And I think that shift, that expansion is pretty clear from that Commission guidance document I mentioned earlier, where that, I think, did specifically warn of the increased risk that foreign investors might attempt to buy up European healthcare capacities, manufacturing capability in PPE or, other kinds of research facilities. So I think it is broader than it would have been pre-COVID.
That seems right. So COVID has really widened what might be considered relevant for FDI. Cal, what do you think about that? Do you have any? Do you agree generally with that, or see any other surprising areas which might be thrown up generally as a result of what we've seen in the pandemic?
I do agree from a Canadian perspective with Lisa's comments. I'd add the following points to answer your question, again, from the Canadian vantage point. First, the minister responsible for the Investment Canada Act has issued a statement on April 18th that all investments that may be controlling or even non-controlling in relation to Canadian business related to public health or the supply of critical goods and services to Canadians or to the government, and it's not limited to the pandemic per se, but it covers the entire health sector. Those are going to be subject to increased scrutiny regardless of the size. So Canada is focusing on the potential effects arising from the pandemic in very significant ways right now. Point number one. Number two, as I've indicated, there may or may not be national security issues, but there's going to be increased scrutiny and greater information demands and likely longer timelines in certain areas under the Investment Canada Act, even apart from national security reviews. and particularly in the healthcare sector. But as the Act is going to be implemented now and going forward on longer timelines, it raises a very real practical issue in regard to distressed or failing firms. The Competition Bureau has issued helpful guidance, as has its counterparts in other jurisdictions, with respect to the review of failing firms in the current environment. And the guidance includes every effort being made by the Bureau to do these reviews effectively, efficiently, and in an expedited timeline, provided the entities are giving the Bureau all the necessary information. So time is of the essence, so to speak, in failing firm reviews. If the Investment Canada Act reviews are going to take significantly longer, what does that mean where there is a potential foreign acquirer of a failing firm? Is it going to frustrate the review? Hopefully it will not. Hopefully they will be able to cooperate with the Competition Bureau. I'm just talking about the impact on parallel reviews. And then lastly, on your question about what we can do in this context, the views of a number of us who advise in this area, and certainly my view, is to go in and see the Investment Review Division as early as possible, so that even before the proposed matter is announced publicly, they can be considering it and providing initial, albeit cautious, guidance. That will likely be of great assistance in this environment. And in fact, we were on a Canadian Bar Association recent program, webinar, in which one of the senior officials of the Investment Review Division emphasized the importance of coming in early, given the potentially longer timelines. Come in early and come prepared, and if need be, in addition to the legal experts, consider having an expert in communications to get it right in terms of public information, as well, if there may be any possible national security issue, consider retaining a national security expert early on.
Absolutely. And thank you for promoting one of our upcoming podcasts on failing firm. That's, as you say, a very important issue thrown up by the recent situation. And we are having a podcast on that coming up, on the failing firm and merger control. Lisa, just coming back to you now. Cal was giving us some practical tips. How do you see it in the EU? As you mentioned earlier, it's a real patchwork. We have the screening regulations stuck on top. Now, what are your key practical tips on how we manage that process in the EU?
Yeah, I think I've probably got 4 or so. So I guess the first one and the most important is that as advisors, we need to be obviously on top of the regulations, which are changing all the time. But we obviously need to be advising our clients that this is out there. It's going to become an increasingly bigger feature, I think, of doing transactions in Europe. So we just need to, make sure that, clients are geared up for that. And that, as new transactions are being thought of, then somebody is also thinking about FDI and, are there concerns? Are there processes to go through, so that all that can be kind of baked into transaction planning? And, clearly as part of that, to the extent that any transaction does need to get an approval or approvals, then, as Cal mentioned, there will be timetable implications of that, and that, will need to be factored in. I guess my third point is a kind of strategic one. Obviously in Europe, I think we are set to see, increasing cooperation between the agencies, including as a result of the FDI screening regulation, which is exactly designed for that purpose. So where you have a transaction which is facing multiple filings, then you need to really be prepared for that and make sure that you have a well-developed and consistent strategy for dealing with multiple agencies. And I think my last point is actually, maybe this is not all bad. There's talk about increasing regulation and impacts for transaction timetables. I think clients might well be put off, but maybe there is a positive point here to mention, which is actually maybe this is an opportunity for some investors. If you are from a friendly country, then you may well have a filing process to go through, but at least outside the arena of investments in industries that are related to the pandemic response, you are unlikely, I think, to get held up in a protracted review process. So potentially, this is a source of differentiation between bids or bidders in competitive contests.
Matthew,
this is really fascinating.
Could I supplement very quickly one of the points about tips for dealing with these issues? And that is, on the Canadian side, the Minister of Innovation, Science and Economic Development will make a decision in net benefit reviews primarily based on undertakings that are proposed by the acquirer. To the extent that counsel for the acquirer can come in early and meet with the investment review division officials with draft proposed undertakings, and particularly in cases where time is going to be quite important, that is the way to go in order to move it along. It's very important. Thank you.
This is great stuff. But let's shift gears a little bit. And Lisa, I'd like to come back to you with a very difficult question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Gosh, well, I'm not sure it's interesting, but I am a mean bread maker. I have spoiled my children by giving them home-baked bread all their lives, and now they won't eat any other type. So you can often find me baking bread at bizarre times of the day and night when, for instance, it's been discovered that there's no bread left for tomorrow's packed lunches, and so some has to be hastily produced. So as I say, I'm not sure that's all that interesting. That's my answer.
And I have a follow-up question, which is, does bread qualify for the Great British Bake Off show? I mean, do they have a bread category?
I think that quite possibly they do, although I'm not sure you're going to see me on that anytime soon.
Because you would have the support of our Curious Amalgam podcast if you were to be on that. Just let us know if that happens, and we can do actually a follow-up podcast.
Okay, noted.
On that. Cal, what about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, apart from the challenge these days to get a haircut when the barbershops open, I'll go back a good number of years to one of the areas I focused on when I was a teenager and into my early 20s, and that was my experience as a canoe trip guide. We call it a canoe tripper in places that are relatively more remote in Canada, such as Algonquin Park, where hundreds of lakes exist and trips are taken into the wilderness. And I spent a great amount of time paddling with younger campers at summer camps, guiding them through some of the most uncharted waters that one might encounter. And it's good training for now when we're facing uncharted waters.
Did you ever run into any bears?
Yes, we did. Yes, we did. We knew if the cub came into our campsite, and in some of these instances, we were in relatively remote areas where there weren't others on the lake, only other animals. If the cub showed up, you had to be prepared very quickly to see the mother not far away. And the last thing you wanted campers to do was to go over and greet that cute little cub. So yes, we saw bears.
Did you ever think about maybe
they weren't after anything other than food? It's not like the situation in Western Canada where there are different risks with grizzly bears.
Did you ever think about maybe sacrificing one of the campers so the rest of you could make it? And if so, how would you choose that camper?
That's a very interesting question. There may have been one or two problematic kids along the way, but usually the worst thing that happened with them was that they ate too much, or they tossed one of their fellow campers into the lake, and what we made them do is wash pots. Thanks.
All right. So now, Lisa, back to you. More seriously, any advice you could give a younger lawyer who wants to get into the competition world?
Good question. I guess, first of all, I would endorse the choice. It's a great area to be in. There's lots of exciting things happening, as you would have heard. And I guess, advice would be to just, really kind of read around. There's lots of developments happening, so you can read about them in the press, and just really try and get a broad understanding of the issues and all the things that are happening in the competition, antitrust, and FDI space.
Now, Cal, back to you. Is there any advice that you wished the younger canoe tripping you had as you went about your career? Is there something you wish somebody would have told you when you were, a teenager that would have, you would like to know now?
Probably some of the best advice I could have learned from was spending more time with a senior canoe guide, a mentor, so to speak. One of the fastest learning curves that I had at that time was going out on a number, 2 or 3 trips with an experienced senior tripper, as we called it. That learning curve went up very quickly in terms of technique, handling campers, caution, safety, and so on. And that does in some way translate into the experience I had joining a large law firm in Toronto back in the 70s, the late 70s, where I had the benefit of a great litigation counsel who I worked with for over 6 years, and the learning curve was very, very much appreciated. We went on a higher tangent than I otherwise would have, and I'm not the only one that learned from him. That tangent was one that I couldn't have done if I practiced on my own. And the other thing I'd like to add is he introduced me to this area, and the area of competition law and foreign investment review continues to evolve both domestically and internationally. And I can't think of any better way to interface with counterparts and jurisdictions across the globe than practicing in these two specific areas: competition law and foreign investment review.
Yeah, and Cal, and you say this, but you've paid this back many times forward, because we know you've been a friend to many of us for a long period of time, and I've watched you be a canoe guide to others. So let's move on to our final segment, which we call The Curious Hat.
And now it's time for The Curious Hat.
We have an actual hat that has actual questions in it. And we're going to, because we're not all together today, I'm going to ask the guests to choose a number between 1 and 15. And then I will read the question on the card that corresponds with that number. So Cal, let's start with you. Choose a number between 1 and 15.
Oh, I was going to invite Lisa to go first. Okay, 1 in 15. I'll take 14.
14. Okay, going near the top. That's a good strategy. Cal, what countries have you visited in the last year?
In the last year, United States, and I believe I was over the last year or so, I was in Paris for an OECD meeting, and also in Hawaii was is part of the U.S. So not that much travel, not as much as I've done in some prior years. I think that's probably it over the last year. A number of trips to the United States, though.
And what's your as you look back, and more than the last year, as you look back, what is your favorite destination?
Well, for enjoyment, at least my wife and I have really loved being in Positano, Italy. The coastal views, the entire environment, the food, and being up high, taking an elevator down through the mountain cliff to the beach. It's unreal. It's surreal in a positive way, not like what many across the globe are going through today. So for vacation, that's our favorite destination. And for work with counterparts in various fora and also on cases, and this goes back to when I was in the Competition Bureau. We had our first bilateral meeting with the JFTC in Tokyo, and since that time I've been involved in a good number of cases with counterparts in Japan from licensing case on, and I've learned so much about the Japanese culture, and we are always received very graciously, very warmly, and with fantastic food. So it would be trips to Japan on the business side. Thanks.
Okay, Lisa, your turn. Choose a number between 1 and 15, but not 14.
Okay, with some trepidation, number 7.
Okay, going right for the middle. Again, not a bad strategy, but here's the question. If you were stranded on a desert island with a DVD player and could only bring 3 movies, what movies would you bring?
Dear me. I would bring E.T., The Devil Wears Prada, and something I haven't watched yet.
You know, that's fascinating because I am having sometimes when you ask this question to guests, you get an answer and you can draw a clear line. I kind of view E.T. and The Devil Has Prada as perhaps polar opposites in terms of the movie, and then in terms of a faith in the movie industry for going forward. Now, why those two movies?
E.T. I would pick because it's a childhood favorite. So it reminds me a lot of growing up. And The Devil Wears Prada because it's a great movie.
Well, with that, thank you to our guests. Wonderful program today, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.